Bismillahirrahmanirrahim. In the name of Allah, the most beneficent, the merciful. In this sitting, we will discuss Lecture 8, Part 4 of International Law. And the basically the Lecture 8 is about the application of international law within state sphere, within the law of land, or within the sphere of law of a country. And in this part, uh, the state practices as to application of international law within municipal sphere. We shall discuss the practices of different states like British, like United States of America, like Pakistan and other imported countries. And first of all, we will discuss the practices of British. The object of present discussion is to ascertain in what manner and to what extent the municipal courts do apply the rules of international law. And there is need to make distinction between customary and treaty rules of international law and between legislature made rules and judicial made municipal law. British practices. There is difference between customary rules of international law and rules laid down by treaties with regard to their application in British. Customary rules. According to British practices, the customary rules of international law deemed to be part of deemed to be part of the law of land and be applied by such British municipal courts subject to two important qualifications. First one, that such rules are not inconsistent with British statute, and the second one, that once the scope of customary rules have been determined by the British courts of final authority, all British courts are hereinafter bound by that determination. According to first, that there should not be any inconsistency between British statutes and customary rules of international law. And according to this, whether the British statutes are earlier in force or later in force, but there should not be any inconsistency. If there should be any inconsistency, then the British statute should prevail. Blackstonian doctrine regarding this theory. According to this doctrine, customary international law was deemed automatically to be part of common law. The rule as stated above through the qualification is somewhat narrow than which was formerly applicable. In Lord Acton, the famous Lord of the the August Court of the British, in Chong Chi Chung reported case 1939, held that the courts acknowledge the existence of body of rules which nations accept among themselves. On any judicial issue, they seek to ascertain what the relevant rule is, and having found it, they will treat it as incorporated into the domestic law so far as it is not inconsistent with rules enacted by statutes or finally declared by the courts. Apart from two qualifications to the rules as stated above, there are two important exceptions to automatic applicability of customary international law by British municipal courts. The first one, acts of states by the executive, for example, a declaration of war or an annexion of territory, may not be questioned by British municipal courts, notwithstanding that a breach of international law may have been involved. Second one, British municipal courts regard themselves as bound by certificate or authoritative statement on behalf of the executive in regard to certain matters falling particularly within the Crown's prerogative. Powers such as de jure or de facto recognition of state, the sovereign nature of government, and the diplomatic status of a person claiming jurisdictional immunity on the grounds of diplomatic privilege. incorporation doctrine, two established rules recognized by British courts. Notwithstanding judicial doubts as to its scope, the incorporation doctrine has left its definite mark in two established rules recognized by British courts. First one, a rule of construction, and second one, a rule of evidence. A rule of construction, this is a very important rule of construction, and in previous exams this short question has been repeated many times. Rule of construction, what is rule of construction? Acts of parliament and statutory instruments are to be interpreted so as not to conflict with international law. Hereby meaning Act of Parliament and delegated legislation, the legislation done under the Acts, are not to be interpreted so as not to conflict with international law. There is need a presumption that Parliament did not intend to commit a breach of international law. And the rule of evidence, international law need not, like foreign law, be proved as fact, expert evidence or otherwise. The British courts will take judicial notice of its rules and may of their own violation refer the textbooks and other sources of evidence thereof. And at the last, in this part, in part 4, the position of British prize courts. It means the position of British prize courts about application of international law. In the matter of giving effect to international law, the position of British prize courts is different from the courts of common law and equity. Prize courts are specifically appointed to apply international law, and according to the leading case, the Zamora, are not bound by any executive order in council which contravenes or purports to alter rule of international law, although presumably they would be obliged to follow an act of parliament in breach of international law. Thank you very much.